Welcome, I am the loud little ducky. Here we are going to go over part 2 of the case review in Owens suing Uber back in 2019. So let's jump in. So this was filed on May 9th, 2019 in the Superior Court of California, County of San Francisco, unlimited jurisdiction. And so this is going to be for Defendant Uber Technologies Incorporated answer to complaint. We went over another person's response and answer to complaint. This is one of the other people because there were so many people, as you can see. It says Laura Owens is the plaintiff, and then like 20,000 people are listed as the defendants, from the driver of the Uber, the Delaware Corporation, Riser LLC, a Delaware Limited Liability Corporation, Riser CA LLC, a Delaware Limited Liability Corporation, Bruce Robert Brogdon, which is an individual in another vehicle that crashed into the Uber, and New Forest Products Incorporated, a California corporation, and Does 1 through 20 inclusive. So Does are like Jane Does and John Does, is from what I gathered in the last filing. These are just random people that are supposed to know about this. And then New Forest is the company that Brogdon was driving his vehicle for. And then it says the judge is Garrett Wong. There's no trial date that was set on this. And the complaint was filed April 4th of 2019. So it says, come now, defendant Uber Technologies, hereinafter defendant, serving itself from all other co-defendants and answering the complaint hereinafter complaint. On file herein as follows. Number 1, inasmuch as the complainant is not verified under the provisions of section 431.30 of the California Code of Civil Procedure, this answering defendant denies generally each and every and all of the allegations in said complaint and the whole thereof, including denial of all sums and amounts alleged to be alleged or otherwise. Separate affirmative defenses. This answering defendant does not, by stating the matter set forth in these defenses, allege or admit that it has the burden of proof and or persuasion with respect to any of the matters, and does not assume the burden of proof or persuasion as to any matters to which plaintiff has the burden of proof of persuasion. So Laura Owens, being the plaintiff, she needs to prove that what she is saying happened and explain why all these people are at fault for this accident. She has to come with proof. You know, this could have happened, but can you prove it? You got to be able to prove things in court. Sometimes that stinks because people can get away with it if you don't have proof, but it is what you have to do. And it doesn't seem like Owens came with a lot of proof in this from the documents that we see, which is usually how she operates. She doesn't usually have much proof, and her proof is doctored or just cherry-picked. So it says, first affirmative defense, appointment of fault. As and for a separate and affirmative defense to the complainant and to each purported cause of action contained therein, this answering defendant is informed and believes, and based thereon alleges. Defendant denies it was negligent in any fashion with respect to damages, losses, injuries, and debts claimed by the plaintiff in the complainant on file herein. However, if this answering defendant is found to be negligent, which supposition is denied and merely stated for the purpose of this affirmative defense. Then this answering defendant provisionally alleges that defendant negligence is not the sole and proximate cause of the result of damages, losses, injuries, and alleged by plaintiff, and that the damage awarded to plaintiff, if any, be appointed according to the respective fault of parties, persons, and entities of their agents, servants, and employees who contributed, I don't know why that became a hard word, and to or cause said resultant damages of alleged according to the proof presented in the time of the trial. That to excess any greater percentage of fault and damages against the answering defendant in excess of this answering defendant's percentage of fault would be denial of California equal protection and the due process and federal equal protection and due process, all guaranteed by the respective constituents. Second affirmative defense, comparative fault. As and for separate and affirmative defense to the complainant and to each purported cause of action contained therein, this answering defendant is informed and believes, and based thereon alleges the injury to the plaintiff, if any, were sustained in the plaintiff failed to exercise ordinary and reasonable care or caution concerning the matters alleged in. Now, I may not agree with that, because if Owens is a passenger and she is using an app, and I don't know if the app shows you if they're insured and when their, expiration of their insurance. I don't know if it shows you that on the Uber app, or if you can look in that, but I don't see how any of this would be the plaintiff's fault or how she didn't do her due diligence and care as far as choosing to take a ride in an Uber. That I don't get. I could be with her on that. The complainant and such negligence on plaintiff's part constitutes a bar to any recovery by said plaintiff, or in the alternative, the recovery, if any, by said plaintiff should be reduced in proportion to the extent such negligence was caused of plaintiff's injuries and damages, if any. Now, if they're talking about her possibly not having health care insurance, I do agree. Her costs should be reduced. You should get what an insured defendant would get, because it is not their fault that you don't have insurance yourself. So I can agree with that as well. So let's go to the third affirmative defense, assumption of risk. As and for separate and affirmative defense to the complainant and to each purported cause of action contained therein, this answering defendant is informed and believes, and based thereon alleges, plaintiff knowingly, willingly, and voluntarily assumed the risk of all damages of, if any. I do not think that by you hopping into an Uber that you are assuming all liability for anything that happens to you in that car. I'm sorry, that is a no. I don't care if there was something signed that says, oh, you can't. Oh, I'll try arbitration. And if arbitration doesn't work, I'm going to sue your ass myself too. But to say that a person that hops into these Lyfts and Ubers and everything else, that no matter what happens, because you signed and you decided to get into that car with that stranger, whatever happens is nobody's fault but your own. I'm sorry, no. And if that's how it is, nobody should be getting into these Ubers and Lyfts, because you don't know what can happen. And if it's going to be all your fault just for you accepting a ride on a platform that is supposed to be safe and vetted, apparently we're all under the wrong assumption. Fourth affirmative defense, equitable indemnity. And so, as for separate defense, blah, 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 thereon alleges and believes. Any and all the events happening, injuries and damages set forth in the complaint, if any, were proximately caused and contributed to by the acts and or omissions of plaintiff, and such acts and or omissions totally bar or reduce any recovery on part of the plaintiff. I don't know how she would contribute. I don't know what acts or omissions she would have done that would bar her from being able to bring this. That would be interesting to know. Fifth affirmative defense, no duty. So they say any recovery on the complainant or any claims for relief of reverent therein is barred to the extent this answering defendant owed no duty to the plaintiff. I don't know that you don't owe a duty to the plaintiff. Some of these people may not have any duty to the plaintiff, but there are some they probably do owe a duty to. Again, we don't know how bad this accident was. We just know there was an accident and that's it. And apparently the Uber driver was on his phone and his insurance had lapsed, so he didn't have any insurance. And so that's all we even know, because nothing in her initial complaint gave much detail as to what happened. The car, I think, spun and maybe faced a different way. But, okay, you got into an accident. And you're like, oh, I needed physical, emotional, and psychological and all this stuff help because of this accident. Well, what in this accident caused you to need those things? What were those things? How extensive was it? Was it something that happened solely from this accident, or was there something in your past that because you had that, this made that worse? We need more details for this to go through. I mean, you look at like the Maya Kowalski case and the amount of detail. This person did this many times and this and this and this. Like there was so much. I don't know if it's because they don't get very far in this lawsuit that we don't have all that, but even in an arrest affidavit, you have to have more in an arrest affidavit to arrest somebody than she had in her initial complaint. I'm not saying these people didn't do wrong and weren't doing something they shouldn't have been doing, but you have to come with details and proof. And you need to let everybody know what that is so that it can move forward in the courts. All right. Sixth affirmative defense, no causation. As and for a separate affirmative defense, therein defendant is informed and believed to the extent plaintiff suffered damages, which defendant denies such injury or damage was not proximately caused by any conduct or inaction of this answering defendant, or was not foreseeable, or both. Is it true? Is it not? We don't know. I mean, you don't know what your drivers are doing out there, so maybe not. I don't think the company can foresee accidents coming, but they need to be able to know what those drivers are doing because they're representing you. Uber is behind their name. They're attached to you. So you better make sure that the people that are repping your company are doing what they're supposed to be doing. That's your job. Seventh affirmative defense, alleged injury or damage caused by others. So this defendant believes, as informed, based on thereon alleges, to the extent plaintiff suffered injury or damage, which defendant denies, such injury or damage was caused by the action or conduct of others, not this defendant. So I think the company, like Uber and Riser, whatever, are trying to say, this is not our fault. It's not Uber's fault. This is the driver's fault. You need to just go after him, not us. Please don't take our money. He was the one driving. The other guy that you're suing that was a part of the accident too, do them. Us companies weren't involved. That's what they're saying here. We didn't do it. The driver did it. Pointing fingers. Existing prior injury. To the extent plaintiff suffered injury or damage, which defendant denies, such injury or damage was sustained prior to the incident alleged by the plaintiff in the complaint on file herein. So they're saying things that she had going on were things that had already happened to her previous. And they're saying there was no injury or damages to her. Ninth affirmative defense, uncertainty. This answering defendant is informed and believes and based thereon alleges plaintiff's complaint and the allegations there are uncertain, vague, and ambiguous, which we already covered in the last part about kind of where she's vague and stuff like that. 10th affirmative defense, limitation on damages, says plaintiff's complaint seeks an award of improper damages, including but not limited to medical damages beyond those permitted by law. So she's asking for too much, and even the law says she's asking for too much. 11th affirmative defense, offset. The cost incurred or paid by the plaintiff, if any, for repair of property damage, medical care, dental care, custodial care, or rehabilitation services, loss of earnings or other economic losses in the past or future were or will with reasonable certainty be replaced or indemnified in whole or in part from one or more collateral sources, including by or through insurance available to the plaintiff under the terms of the Patient Protection and Affordable Care Act. And as such, the defendant is entitled to have an award reduced in the amount of such payments. So, Patient Protection Affordable Care Act. And she's entitled to those defenses, so she shouldn't get paid by that act. And then the defendants have to pay that as well, so she's kind of getting double paid for that. So they're saying, nope, we should deduct that part off. We can't be she doesn't need to be double dipping. All right. And so a healthcare reform law, the Patient Protection and Affordable Care Act is a healthcare reform law that was signed into law by President Barack Obama on March 23rd, 2010. And the goals are making affordable healthcare insurance available to more people, expanding Medicaid, improving the quality of fairness and affordability of health insurance, reducing healthcare costs, improving healthcare value and efficiency. And so this is all about her not having insurance when she could have insurance. With the Affordable Care Act, she should have health insurance, and it's not their fault that she doesn't. And deduct what they would have paid on it off of the defendant's total amount owed. 12th affirmative defense, Howell versus Hamilton meets. Plaintiff's recovery for past medical expenses or other economic loss or benefit, if any, is limited to the lesser of the amount paid of the reasonable value of those services or benefits. 13th affirmative defense, Patient Protection and Affordable Care Act. Plaintiff is excluded from recovering any amounts which have been or will indemnify plaintiff for any past or future claim medical expense, health care, life care, or other economic loss or benefit that is offered or provided under or is in connection with the Patient Protection and Affordable Care Act. 14th affirmative defense, failure to obtain health insurance. So I'm guessing she didn't have health care insurance, because I don't know why they would be making these arguments if they knew she had insurance. So they either don't know if she has it and are just doing it to cover their butts, or they know for sure she didn't have health care insurance, which maybe that's why she does telehealth, because it's cheaper and she doesn't need insurance to do it. In the event plaintiff has failed to obtain healthcare insurance coverage available to the plaintiff, which she is eligible to obtain under the Patient Protection and Affordable Care Act, plaintiff has failed to mitigate plaintiff's damages and cannot recover for such failure. 15th affirmative defense, failure to utilize health insurance benefits. To the extent plaintiff failed to take reasonable steps to utilize the resources, service benefits, and coverage available to plaintiff under the Patient Protection and Affordable Care Act, plaintiff has failed to mitigate plaintiff's damages and cannot recover for such failure. Right. You ain't getting all this money, child. 16th affirmative defense, Affordable Care Act and future damages. As in separate affirmative defense to the complainant and to each purported cause of action contained therein, this answering defendant is informed and believed, and basis thereon alleges. Plaintiff will be limited to the reasonable value, if any, of future medical services available to the plaintiff under the Affordable Care Act. So get you some health care insurance, because we're not paying for future stuff still just because you don't get insurance and you refuse to get it. You don't have it and you aren't going to get it. You aren't getting money from us just because you won't do that. That's there for a reason. Take it. 17th affirmative defense, no injury or damage. This answering defendant denies plaintiff suffered any injury or damage whatsoever and further denies it is liable to plaintiff for any injury or damage claimed or for any injury or damage whatsoever. So they say there was no injury. It was a wreck, but she wasn't harmed, is what all of these defendants are saying. That's, you can expect that. Whether it is true or not, I don't know. But they're going to say, no, she wasn't hurt. Yeah, it was an accident and it wasn't great, but accidents happen, but she didn't suffer anything from it. And I doubt she's just quit taking Ubers anymore. I bet she still takes Ubers. So it didn't scar her for life where she won't get into a rideshare ever again. 18th affirmative defense, vicarious liability. This answering defendant denies plaintiff suffered any injury or damage whatsoever and further denies it is vicarious liability for the acts of the other parties. 19th, fails to state facts, general. This is where she's vague and ambiguous and there's uncertain. The complainant and each purported cause of action contained therein fails to state facts sufficient to constitute a cause of action against this answering defendant. And I do agree with that. There is not enough facts. 20th affirmative defense, statute of limitations. Defendant informed and believes and based thereon alleges each said cause of action is barred by the applicable statute of limitations, including but not limited to California Code of Civil Procedures sections 335.1, 337, 337.1, 337.15, 338, 339, 340, and or 343, which that was mentioned in the other people's affirmative defenses as well. But I don't think 2 years, I don't think she's past it. I don't think she's past it. I think she's right at the 2-year mark, which I think is the statute of limitations, but I don't know. I tried to look and it looked like maybe there was 2 to 4 years that you could file. So moving to the 21st affirmative defense, failure to mitigate loss. If plaintiff suffered in any damage as a result of the allegations set forth in the complaint, plaintiff is not entitled to recover from this answering defendant any sum of damages due to plaintiff's failure to take reasonable efforts to mitigate the damages said plaintiff allegedly incurred. Yes, she needs to mitigate some of those with health care insurance. They do go into estoppel, waiver, latches, unclean hands, and collateral estoppel, which it says each and every cause of action, purported cause of action contained in the complaint is hereby barred by the doctrine of estoppel, by the doctrine of waiver, by the doctrine of latches, barred by the doctrine of unclean hands, and I'm guessing barred by collateral estoppel, but let's see. Yes, barred by the doctrine of collateral estoppel. So we've covered all those. So now we're to 27th, affirmative defense, voluntary conduct. Plaintiff has engaged in conduct with respect to the activities and or property which are subject of the complaint, and by reason of said activities and conduct is stopped from asserting any claim or damages or seeking any other relief against the answering defendant. 28th, affirmative defense, damages uncertain. Plaintiff's damages, if any, are speculative, uncertain, and not capable of being determined by a trier of fact. Yeah, you don't have enough details. We're very uncertain about what your damages are. How can somebody decide what they are? We don't know what they are. You didn't state what they were. 29th, affirmative defense, intervening, superseding cause. The damages of which plaintiff complains were approximately caused or contributed by the acts of other defendants, persons, and or entities. Such acts were an intervening, supervening, and superseding cause of the injuries and damage, if any, of which the plaintiff complains, thus barring plaintiff from any recovery against the answering defendant. 13th affirmative, 30th, not 13. 13 was a long time ago. 30th affirmative defense, no vicarious or agent liability. As in for separate and affirmative defense to the complainant, defendant alleges that at no time or place set forth in the complaint did any other defendant or third person allege to be at fault operate as the agent or employee of defendant, such that defendant can be held vicariously liable for their acts. Should any other defendant or third party be deemed to have any affiliation with this defendant, then such other defendant or third party was independently responsible for their own means and methods. Accordingly, the doctrines of respondent, superior, and agency are inapplicable, and the answering defendant has no vicarious liability for acts or omissions by said other defendants and third parties. Independent contractor. So this is the one where they're like, this is the driver. They're an independent contractor for us. We are not them. They just work under our name. So it says, this answering defendant alleges that the complaint and each cause of action set forth therein is barred in whole or part under the independent contractor defense, as an independent third-party transportation provider was an independent contractor responsible. The independent third-party transportation provider's own means and methods, making the doctrine of respondent superior inapplicable. Now, this could be true. This could be where Uber is like, they are independent. They are not employees of us. They are independent and they have things that they have to do. In my job, I am an independent contractor. I work under an umbrella, so I'm attached to their name, which it could affect them. But certain things that I do are solely on me. Most of what I do is solely on me. Could it disgrace the umbrella that I work under? Absolutely. Which is why I don't do those things. And I get really mad if somebody does try to come in there because my name is attached to that. So if somebody was, messing up for Uber and I worked for Uber, I'd be very upset when people are doing things that shame Uber because my name is attached to that. and that is the way I make money for my family. And if you want to come in and screw with my money under a company that I am associated with, I'm going to have a huge problem with you, because then you're kind of affecting me. You do you. Don't come over here affecting me, though. But they're saying these independent contractors are separate. Yes, they work under our umbrella, but they are independent. 32nd affirmative defense. The complainant and each and every cause of action therein alleged against defendant fails to set forth facts sufficient to constitute a cause of action against this answering defendant. 33rd affirmative defense, joint and several liability. As for separate affirmative defense, this answering defendant alleges that the liability of this answering defendant for the non-economic damages claimed or proven by plaintiff shall be and limited by California Civil Code 1431.2. 34th affirmative defense, lack of capacity to sue. Defendant is informed and believes and based thereon alleges plaintiff lacks legal capacity to sue and is not the real party in interest and is thus barred from any recovery against the answering defendant. I don't know that she is not a party that can sue. I don't know where she lacks capacity at, and how she's not the real party in interest. I mean, maybe Brogdon is the real party who has the legal capacity and not Owens, but I don't know. It could be Zayed. He could actually be the one that is owed the stuff. It was his car, and such, and he was just driving, and the other guy, Brogdon just drove by and was driving at an ungodly speed, or something. And so they're saying that because she was a passenger, she maybe lacks the capacity to sue and isn't the real party. I don't know how well that would go. We would need more information, which we don't have. I'm sorry, I hit the mic just now. 35th affirmative defense, sudden emergency doctrine. Any and all claims that the plaintiff may have or had against defendant have been or will be barred by the sudden emergency doctrine. Consent is the 36th affirmative defense. Each and every cause of action or purported cause of action contained in the complainant is barred due to the consent by the plaintiff to all actions alleged therein. Contractual indemnity, number 37, is the independent third-party transportation provider is contractually obligated to defend, indemnify, and hold defendant harmless for all claims asserted by plaintiff. Interesting. 38th is the arbitration. When you sign the little contract, the dispute is subject to arbitration agreement between plaintiff and the answering defendant, such that this matter is purportedly brought before a qualified arbitrator rather than taking it to court. Take it to the arbitrator, don't take it to the court. See if they will do something for you, and then if you can't get it that way, then you can go to the court. But you need to try arbitration first, is basically what they say, and you didn't do that. No seatbelt usage. To each purported cause of action therein, this answering defendant is informed and believed and thereon alleges plaintiff recovery is barred or purportedly reduced due to this plaintiff's failure to wear available restraint device and to wear it properly. So she either didn't wear a seatbelt, which she should have, or she wore the seatbelt, but she didn't wear it correctly. Like maybe she put the strap that goes in front of you behind her. And the other defendants also put that in theirs. 40th affirmative defense, reserved defenses. As and 4 separate and affirmative defense to the complainant, and as each purported cause of action contained therein, this answering defendant alleges that it presently has insufficient knowledge or insufficient information upon which to form a belief as to whether it may have additional yet unasserted affirmative defenses. Defendant therefore reserves the right to assert additional affirmative defenses in the event discovery indicates it would be appropriate. So with the little information that we have, these are what we're fighting with. But if more information comes out, we're going to reserve the right to defend ourselves further. Wherefore, this answering defendant prays for judgment as follows. Number 1, plaintiff takes nothing by virtue of plaintiff's complaint. 2, for cost of suit incurred herein. And 3, for such other and further relief as the court may deem just and proper. Signed by the attorneys for Uber Technologies Incorporated, Riser LLC, and Riser CA LLC, and that is dated May 9th, 2019. So here we have defendant Zaid answer to plaintiff's complaint. So this is the driver of the Uber, and this was filed on July 22nd, 2019 in the Superior Court of the State of California, County of San Francisco, against Laura Owens. Comes now the defendant Zaid as an individual and answers the complainant herein as follows. It appearing that complainant herein is unverified, defendant files his general denial pursuant to California Code of Civil Procedure 431.30D. 2, defendant denies general and specific each and every allegation of said complainant, both conjunctively and disjunctively, and the whole thereof, and further denies that plaintiff has been damaged in the sum alleged or in any other sum or at all. Affirmative defenses. For further and separate distinct defense, this answering defendant alleges that plaintiff's complaint in each alleged cause of action herein fails to state facts sufficient to constitute a cause of action as to this answering defendant. And then further and separate distinct defense, this answering defendant alleges that at the time and places mentioned in the complainant, plaintiff was careless, reckless, and negligent in and about the matters and things alleged in the complaint, which said carelessness, recklessness, and negligence concurred in point of time with the alleged negligence of defendant, if any there may have been, and legally caused or contributed to whatever injury and or damage plaintiff may have sustained, if any, and recovery by plaintiff, if any, should be proportionally reduced according to the percentages of fault of plaintiff. For further, separate, and distinctive defense, this answering defendant alleges that at the times and places mentioned in the complaint, plaintiff did commit willful misconduct in and about the matters and things alleged in the complaint, which said willful misconduct concurred in point of time which the alleged willful misconduct of defendant, if any there may have been, and legally caused and or contributed to whatever injury and or damage plaintiff may have sustained, if any. Okay, whatever all that means. I don't know how the plaintiff is at fault for some of these things. For further and separate and distinct defense, this answering defendant alleges that in addition to the aforementioned negligence of plaintiff, and injury and or damage incurred by plaintiff was directly and legally caused and contributed to by the negligence and or fault of the third party persons or parties. This answering defendant are informed and believe, thereupon alleges that the plaintiff did, with full knowledge of the facts, dangers, and consequences of her own actions or inaction, and of the actions or innate action of defendant, expressly implied and voluntarily accepted the risk incident thereto. So by hopping in a car with you, she knew the dangers. Well, if you were actually on your phone, then I guess she wouldn't know the danger that her driver was going to be on the phone, not paying attention to the road if that in fact happens. So I don't think by getting in the car, you're like, okay, whatever unlawful behavior you want to do, I'm going to take a risk by riding with you. No, we're expecting you to follow the rules of the law and the laws of the road. So I don't know if I agree with that one. And then let's see. Okay, number 5. This answering defendant are informed and believe thereupon alleged that plaintiff did with full knowledge of. Okay, so we read that one. So number 6. This answering defendant is informed and believes, and upon such information and belief alleges that at the time and place alleged in the complainant, plaintiff was engaged in a joint and common enterprise with other persons or parties, that negligence or fault of the plaintiff and each other person or party is imputed to the other. The plaintiff and each of the other persons or parties was careless, reckless, and negligent in and about the matter and things alleged in the complaint, which said carelessness, recklessness, and negligence concurred in point of time with the alleged negligence of defendant, if any, there may have been, and legally caused and or contributed to whatever injury and or damage plaintiff may have sustained, if any. Number 7, the answering defendant alleges that the events, injuries, losses, and damages complained of, if there were the result of an unavoidable accident insofar as this answering defendant is concerned and occurred without any negligence, want of care, default, or other breach of duty or the part of said defendant. So that he is saying that he did nothing. It was just an unforeseeable accident. He didn't do anything wrong, is what he's saying. So he shouldn't be sued. Number 8, further separate distinct defense to the plaintiff's complaint in each alleged cause of action therein. This answering defendant is informed and believes, and thereupon alleges that at the time of the accident mentioned in plaintiff's complaint, plaintiff was employed by an employer providing workers' compensation benefits as a result of such accident and any injuries sustained thereby. That at the time and places mentioned, the plaintiff's complainant said employer was careless, reckless, and negligent in and about the matters things mentioned in the complaint, that the negligent plaintiff's employer and employees of said employer is imputed to said employer so as to bar and or limit recovery herein, accordance with the doctrine of Witt v. Jackson, a 1961 case. For a further separate and distinct defense, the answering defendant is informed and believed, and upon information and belief alleged that the plaintiff, by exercise of reasonable effort and or care, could have mitigated the damages alleged to have been suffered, but plaintiff has failed, negligence, and refused and continues to fail and refuse to exercise reasonable efforts to mitigate the damages, if any. So she is refusing to get insurance or try to get some of the costs to go down. This answering defendant alleges that the plaintiff could have avoided damages by reasonable effort or expenditure, that the plaintiff's cause of action and each of the set forth in the complaint herein is barred by applicable statute of limitations, including but not limited to CCP 335.1. So they're saying it's too late for you to file this. This answering defendant alleges that pursuant to California Civil Code 1431.2, any liability of defendant for non-economic damages is several only and not joint. The defendant is liable, if at all, only for the amount of non-economic damages allocated to such defendant in direct proportion to defendant's percentage of fault. For further and separate and distinct defense, this answering defendant alleges the plaintiff complaint and each alleged cause of action therein is barred by the provisions of Civil Code 3333.3. Then it goes on to say, for further and separate distinct defense, this answering defendant alleges that the purported to the Personal Responsibility Act of 1996 and the Civil Code 3333.4, adopted by Initiative Proposition 213 at the November 5th, 1996 general election, effective November 6, 1996, plaintiff complaint and each alleged cause of action herein is barred and plaintiff precluded from recovery against defendants for any non-economic losses to compensate for pain, suffering, inconvenience, physical impairment, disfigurement, or other non-pecuniary damages. Interesting. This answering defendant is informed and believes upon such information and beliefs alleged that the plaintiff has engaged in conduct with respect to the activities and property which are the subject of the complainant, and by reason of said activities and conduct is stopped from asserting any claim or damages or seeking any other relief against the answering defendant. So they're saying you cannot do that. And then, let's see here, let's look up this personal responsibility. Act. What is it? Because we need to know these things. Open-ended entitlement. Change legal immigrant. Eliminates all existing federal requirements of I don't know what that act did for anybody. I'm not understanding that, but okay. So they're saying they were stopped. They stated something about the Civil Code and the Personal Responsibility Act. The answering defendant is informed and believes, and upon such information and belief, alleges that plaintiff has engaged in conduct and activities sufficient to constitute a waiver of any alleged negligence or any other conduct, if any, as set forth in the complaint. This answering defendant is informed and believes, and upon such information and belief alleges that due to the tardiness in asserting its purported right to recover, plaintiff's claim should be barred by the equitable doctrine of laches. So they're mentioning the doctrine of laches as well, and estoppel and all of that, like everybody else. They say, by virtue of plaintiff's unlawful, immoral, careless, negligence, and other wrongful conduct, plaintiff should be barred from recovering against the answering defendant by the equitable doctrine of unclean hands. We've heard that one. This answering defendant is informed and believes, and upon such information and beliefs, allege that he acted with reasonable care in an emergency situation. So the driver is saying, I acted as one should in a situation like this. Nothing I did was out of the ordinary. And because the complainant is couched in conclusory terms, this answering defendant cannot fully anticipate all affirmative defenses that may be applicable to the within action. Accordingly, the right to assert additional affirmative defenses, if and to the extent that such affirmative defenses are applicable, is hereby reserved. So they're saying, just like everybody else, if we need to put in more affirmative defenses, we are reserving our right to do so, because this is not all that should be in a complaint. It's just so uncertain, vague, and ambiguous that we still reserve the right for more defenses. Wherefore, this answering defendant prays that the plaintiff take nothing by way of plaintiff's complaint, and defendant goes hence with defendant cost of suit, and for such other and further relief as the court deems proper. Wherefore, defendant prays that 1. The complaint be dismissed in its entirety with prejudice. which means she can't file it again. 2, the plaintiff takes nothing by this action. 3, defendant be awarded cost of suit incurred herein. So they want her to pay for bringing this suit. Defendant be awarded such other and further relief as the court deems just and proper. And then it is signed by Zaid's attorney on July 22nd, 2019. All right. So now we're going to move on to the proof of service, Code Civil Procedure 1013A, Owens v. Zaid, State of California, County of Santa Clara. I am employed in the County of Santa Clara, State of California. I am over the age of 18 and not a party to the blank within action. My business address is blank. On July 22nd, 2019, I served the foregoing document described as Defendant Zaid. Answer to plaintiff's complaint on the other parties in this action by placing the true copies thereof enclosed in sealed envelopes and addressed as listed. And they did it by mail. And then they signed it. So everybody was served that needed to be served. And they sent it to Owens, Brogdon, and New Forest Productions, and then they sent it to Uber and Razor, whatever it is. All right. Then we have this, which is Notice of Settlement of Entire Case. And this was filed on August 16th, 2019. And so it says plaintiff's attorney, which was the Cotchett, Petrie, and McCarthy, Uncle Joe. To the court and all parties and any arbitrator or other court concerned ADR neutral involved in this case. This entire case has been settled. The settlement is unconditional. A request for dismissal will be filed within 45 days after the date of settlement. Date of settlement is 8/15/2019. Purpose, case management statement is listed. Trial date, no trial date is set, and then it was signed. So it's just saying, hey, this was already settled. Then we have proof of service, first class mail, that it was sent to the respondent, proof of service via mail, and then it was sent to the people it was supposed to be sent to. It says this court has been notified this case is settled pursuant to California Rules of Court Rule 3.1385. The court will dismiss the case unless good cause is shown as to why it should not be dismissed. So it is dismissed. I don't know who dismissed it. I don't know what the settlement is of this or if she got anything, but these are the documents that we have for this particular case. And it was officially basically closed out and dismissed as of August 21st, 2019. And then, you know, everybody got their certificate saying this case is closed, donezo. Now, let's go into some of this stuff and evidence that we have from around this time from Laura Owens. So the accident happened on April 6, 2017. She states in a story that my grand mal seizures happened in May 2017, and again, this video was taken June 2017. Bottom line, my epilepsy was not caused by a fall from a horse. So she's saying right here it was not caused from a horse, but her seizure happened in May, so a month after the accident. So let's see what else she has given us, because she gives us so many gems. So here is something she posted in a Medium blog. and then we're going to go over some texts. The truth about the fall and false claims of my origin of my epilepsy. It's hard to know where to start with this one. I didn't land on my head. I landed on my feet. I didn't go to the hospital after. JFC. I sued Uber, but never got a cent from them and never referred to my epilepsy or seizures. Sorry to burst your bubble. Okay, well, we saw the case was dismissed, so maybe that's why you didn't get a cent. Doesn't mean you didn't try to get some cents. And I falsely claimed, quote unquote, that my ex strangled me, as if anyone besides me and Mike were there for every moment of our relationship between 2016 and 2017. We are the only two people who know what happened, and guess what? He knows what he did to me. Conveniently, he says that my epilepsy was as a result of this fall and not his abuse. Really? This fall caused it? So that is what she has to say there. She never blamed it on the Uber, is what she's saying here. It's always been Mike. She's always said it was him. So some text messages from May 23rd, 2017. How are you feeling? And then it is, she gives some like, ugh, face. I would love for you to come. It's a lot to explain. Maraschini says, can you talk now? I just want to be held tonight. Maraschini, that doesn't answer my question. 5/23, 2017. In elevator, released. Sorry I yanked your neck to kiss you. Sorry for my mood too. I really don't feel good at all. He says, what's wrong? And later there's a message that says, yes, thank goodness. It was a really long drive. Forgot to take my seizure medication last night. And that was in July 22nd, 2017. So then we have an excerpt from a declaration from Laura Owens that that we've read 100,000 times, but it's, good girl. I felt panicked and didn't understand what he was doing. I was crying. I kept thinking I didn't want to do anything to upset him as he did this, since I didn't want to push him over the edge. After he stopped having sex with me, I asked why he put his fingers down my throat and told him I didn't like it. He brushed it off and ignored me. On another occasion in February 2017, Mr. Maraschini strangled me during sex so hard that he left red marks on my neck. I sent pictures of the marks to my sister, but did not save the photos because I was afraid he would find them. I deleted my pictures and text for this reason. There are 2 other occasions when I had marks on my neck where he strangled me. I cannot remember exactly when it was, but believed it was in May and July of 2017. Imagine that. Just coincides with the accident. Sometime in February 2017, I noticed tiny red spots around my eyes. Mr. Maraschini strangled me, which I now know is petricular hemorrhage. You don't know that. You haven't been diagnosed with it. You Googled it. This became common and took photos on a couple of occasions. See Exhibit 4, photos of redness around right eye and cheek taken March 2017. And Exhibit 5, photo of redness around my eyes and circles taken May 2017. Sometimes my eyes were also bloodshot and I had dark circles around my eye sockets. At one point, my mom confronted me about the red spots and I asked how I got them. I told her Mr. Maraschini was strangling me during sex and that I believed the tiny spots were a result of the strangulation. Yet you don't need to believe things. You need to go to a doctor and get diagnosed. Stop Googling what you think you have. Google is not the answer. Here's some more text during that time period. May 23rd, 2017. Would you want to come over tonight so I'm not alone? Marasini says, I don't understand why they let you go each time when you keep having seizures. Can you please get back to me? I really need you. It will be really soon, but my door is unlocked if you want to go there. Marashini says, how far are you? What's going on? How are you doing? Then he says, hello. And so then we get to, oh, these are even earlier, May 2nd of 2017. Just FYI, I'm going to St. Francis ER to be safe. I really have a terrible headache and I don't feel myself. And a possible bad brain injury isn't something I want to take a chance with. I'd have to have the imaging soon regardless. She says, no brain bleed. Phew, come home and have to follow up with the Cochet neurologist. Hope you are feeling better. XOXO. Okay. So now there's a Cochet neurologist and a Cochet lawyer. Okay. Mike says, oh my God, are you okay? She says, just woke up. Holy cow. Don't feel so hot today. Have to go to the barn now, but my mom is going to drive. Need to book San Diego on the way up. He said, are you sure you still want to go after feeling this poorly? Yep, definitely. I have a couple prescriptions to pick up. It's exactly what I need. Can't wait. I'll send you hotel options. So that's on the 23rd. 23rd, she says, I had a massive seizure and I'm on way to St. Francis in an Anglorean election. Okay. So she's having seizures. Mike is not even around when she's having these seizures. And if he caused them, why do you want him there with you? Like if he gave you these seizures, he strangled you. Oh, I don't want to be alone tonight. So you want him to come strangle you and give you more seizures? That doesn't make any sense, woman. God, just so many lies. Make it make sense. She says, ambulance. Marashini says, can you call? She says, I'm in an ambulance to St. Francis. Looking good so far. Looks like I will be able to go home provided my blood tests are normal. They're going to put me on an anti-seizure drug. So that was on the 23rd of May in 2017. May 1st, 2017. I had a seizure on Wednesday night, and I've never had one in my life. Didn't want to tell you because I didn't want you to worry, but it was horrendous. I thought I was going to die. I've never had one before. I hit my head so hard that I was knocked out cold for more than a minute. Apparently that just takes the lawsuit into a new stratosphere. I really don't want to have a seizure again, so I hope they're resolved from that standpoint. But Joe Cochet said you don't just randomly start having seizures at 26 if you've never had one before. So it's likely something that happened because of the accident. Ding, 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 ding. But you never blamed it on the accident. You always blamed Marashini, right? Once again, you're caught in your own lie. Marashini says back, my God, I'm sorry to hear that. Can he prove a correlation? She said he's sending me to a neurologist, but I'd imagine so since I've never had one before. So, okay. So Cochet neurologist means that it's the neurologist that Joe Cochet, Uncle Joe, was sending her to. It's not something else. Because I was like, what in the world? So that makes more sense there. Marashini says, where were you Wednesday night? Were you with family? She said, I was home alone and making Sarah's cake. I'm all bruised from it and I have a big bump on my head. How do you know you were out for a minute? How do you know you had a seizure? That's a good question. How do you know those things? Maybe you just got a concussion, not a seizure, and just blacked out. So she says, I was on the phone with mom. I told her I wasn't feeling good and I was feeling like my fingers were tingling, and then I fell down and dropped the phone. I called her back a few minutes later, but I don't really remember talking to her then. I'm 100%. More percentages. I just got the referral from a neurologist today, so I'm going to go. She says, did you go to the doctor? Marashini asks. And then she sends something about his and hers Tesla. And then on the 2nd of May, she says, I'm feeling super spacey and I feel like I might have a seizure again. So she keeps having these seizures. And so she says, like, I don't know if she actually did or didn't. There has been no proof other than that she has seen a neurologist. We don't know if the neurologist has diagnosed her with seizure, has actually seen her have a seizure, or that her brain waves from any of these ER visits have picked up that she had had one. Because I had an ex who had seizures, and we would go to the emergency room if he had had one, and they would do a bunch of tests, but they would be able to like look at his brain to see when kind of the seizure was, or if there's still activity from the seizure, because it does things to your brain. And so doctors can see, all that type of stuff with imaging or and other tests such like that. So this is what she says she has done. We have no proof to say she has or she hasn't. She's on medication for seizures, supposedly, and I think they got that through some mental health records or her neurologist records during the Clayton v. Owens case. But that is what we have for the Uber lawsuit. Next, we will have to check into the Lone Star construction thing or Lone Cactus construction thing. So hit the like button, subscribe, and turn those notification bells on, and I will see you next time. Bye.